Book 1 General Provisions. Chapter 1 Tenor of Code, Purpose of Civil Actions, Obligations of Court and Parties. Article 1. Tenor of Code. Procedures relating to civil actions shall, except as otherwise provided by other laws, conform to the provisions of this code. Article 2. Purpose of Civil Actions, Right to obtain trial. 1. The purpose of civil actions is to have courts resolve civil disputes in accordance with the law in order to protect the rights of private parties. 2. The right of all persons to obtain a court trial in a civil dispute shall be guaranteed. Article 3. Right to request examination, the principle of law contradiction. 1. No party shall be tried without being heard or summoned. 2. The court shall, in all cases, preserve the principle of law contradiction. Article 4. Obligations of court and parties. Courts shall make efforts to ensure that civil actions are conducted fairly and speedily, and parties shall pursue civil actions honestly and in good faith. Article 5. Language used at court, right of party to request interpreter. 1. The Khmer language shall be used at court. 2. A party who cannot understand the Khmer language may hire a qualified interpreter. Where a party cannot afford to hire a qualified interpreter, the state shall provide a qualified interpreter. Article 6. Attendance of public prosecutors. 1. Where the court deems it necessary for the public welfare, the court shall notify public prosecutors of the receipt of a complaint on a case that may possibly require the attendance of public prosecutors. 2. Regardless of whether public prosecutors have received a notice described in paragraph 1, public prosecutors may, where they deems it necessary for the public welfare, attend the proceedings of a civil action and present opinions. Chapter 2 Court, Section 1. Jurisdiction, Article 7. Meaning of court having jurisdiction. A court having jurisdiction, shall mean a court that has the right to receive a complaint, adjudicate an action, and render a judgment. Article 8. Jurisdiction conferred by address, etc. Actions against the following types of persons shall be brought in the court of first instance that has jurisdiction over the location indicated below. A natural person. 1. His, her domicile. 2. The location of residence, where such natural person does not have a domicile within Cambodia, or where his, her domicile is unknown, or, 3. His, her last known domicile, where such natural person does not have a location of residence within Cambodia, or where the location of his, her residence is unknown. B. A Cambodian juridical person. 1. The location of its administrative headquarters or business office, or, 2. The location of the domicile of the entity's representative or other principal person in charge of the operations of the entity, where there is no administrative headquarters or business office. C. A foreign juridical person. 1. The location of the entity's administrative headquarters or business office in Cambodia, or, 2. The location of the domicile of the entity's representative or other principal person in charge of the operations of the entity in Cambodia, where there is no administrative headquarters or business office within Cambodia. Article 9. Jurisdiction based on property, etc. In addition to the courts specified in Article 8, jurisdiction conferred by address, etc. The following types of actions may also be brought in the court having jurisdiction over the location set forth below. A. Actions demanding performance of obligations, the location where the obligations are to be performed. B. Actions demanding payment of money on bills or checks, the location where payment on the bill or check is to be made. C. Actions demanding performance of obligations against persons who have no domicile in Cambodia, or those whose domicile is unknown, the location of the defendant's property which is the subject of the claim or security interest, or which may be seized. D. Actions demanding performance of obligations against juridical persons that have no administrative headquarters or business office in Cambodia, or those whose administrative headquarters or business office is unknown, the location of the defendant's property which is the subject of the claim or security interest, or which may be seized, actions against persons having an administrative headquarters or business office and pertaining to business transacted therein, the location of the administrative headquarters or business office, actions based in tort, the location where the alleged tort occurred, actions pertaining to immovables, the location of the immovable, action pertaining to registration, the location at which the registration is required, actions pertaining to deceased's estate, the location of the domicile of the deceased at the time the inheritance commences, or if such person does not have a domicile in Cambodia or her domicile is unknown, the location of her residence, or if such person does not have a location of residence in Cambodia or her location of residence is unknown, the location of her last known domicile. Article 10. Special jurisdiction in cases involving divorce, parent-child relationships. 1. An action for divorce or an action to confirm the existence or non-existence of a parent-child relationship shall be heard exclusively by the court of first instance having jurisdiction over the location of the domicile of the person whose statute is related to the action. 2. Where the domicile described in paragraph 1 is not within Cambodia, or where a domicile within Cambodia is not clear, the location of residence shall be used. Where there is no location of residence, or where such location of residence is unclear, the last known domicile shall be used. Article 11. Jurisdiction over joint claims. Where one action encompasses multiple claims that are subject to the jurisdiction of different courts, all claims may be brought in the court having jurisdiction over one of the claims. Article 12. Designation of court having jurisdiction. Where the court having jurisdiction cannot exercise its jurisdiction for any reason based in law or fact, or if the court having jurisdiction cannot be designated because the jurisdictional district is unclear, the Supreme Court shall, upon motion and by ruling, determine the court having jurisdiction. Article 13. Jurisdiction by agreement. 1. An agreement that determines the court having jurisdiction shall be valid only where it is made between merchants and/or juristic persons with regard to the court of first instance. 2. The agreement referred to in paragraph 1 shall not be valid unless it pertains to an action based on a specific legal relationship and is made in writing. Article 14. Jurisdiction as a result of failure to raise objection. Where, at the court of first instance, the defendant makes statements on the merits at the court dates of the preparatory procedure for oral argument or offers argument on the merits at the court dates for oral argument without contesting jurisdiction, the court shall be deemed to have jurisdiction over the case. Article 15. Exception in case of statutory exclusive jurisdiction. The provisions of Articles 13, Jurisdiction by agreement, and 14, Jurisdiction as a result of failure to raise objection, shall not apply to actions regarding which exclusive jurisdiction is conferred by law. Article 16. Examination of evidence on court's own authority. The court may examine evidence on its own authority in regard to matters relating to its jurisdiction. Article 17. Time of determination of jurisdiction. The jurisdiction of the court shall be determined as at the time when a complaint is filed. Article 18. Handling of situations where jurisdiction does not exist. 1. Where the court determines that it lacks jurisdiction over all or part of an action, it shall transfer such action or part thereof to a court having jurisdiction, upon motion or on its own authority. 2. The motion for transfer shall be made in writing, except where it is made at a court date. Where such a motion is made, the reasons for the motion shall be clearly stated. Article 19. Transfer to avoid delay, etc. 1. A court of first instance may, even where an action falls under its jurisdiction, upon motion or on its own authority, transfer all or part of such action to another court having jurisdiction if it determines that such a transfer is necessary in order to avoid significant delay in the progress of the action, or in the interest of fairness to the parties. Such transfer shall take into account the location of the domiciles of the parties and the witnesses to be examined, the location of the objects to be inspected, and any other relevant matters. 2. Where a motion is made by a party pursuant to paragraph 1, the court shall consider the opinion of the other party when making its ruling. When determining on its own authority to order a transfer pursuant to the provisions of paragraph 1, the court may consider the opinions of the parties. Article 20. Restriction on transfer in case of exclusive jurisdiction. The provisions of Article 19, transfer to avoid delay, etc., shall not apply where the action falls by law under the exclusive jurisdiction of the court before which the action is pending. Article 21. Tromto appeal. A tromto appeal may be made against a ruling ordering a transfer or dismissing a motion to transfer. Article 22. Binding effect, etc. of transfer ruling. 1. Where a ruling to transfer an action has become final and binding, the ruling shall be binding on the court to which the action has been transferred. 2. The court to which an action is transferred may not transfer the action to another court. 3. When a ruling to transfer an action has become final and binding, the action shall be deemed pending ab initio before the court to which it has been transferred. 4. When a ruling to transfer an action has become final and binding, the court issuing the ruling to transfer shall forward the record of the case to the court to which the action has been transferred. Section 2. Structure of courts. Article 23. Individual and panel systems for trials of first instance. 1. Courts of first instance shall handle cases by a single judge, except for the cases described in paragraph 2. 2. The following types of cases shall be handled by a panel of judges: A. Cases in which the value of the subject matter of the action equals or exceeds 5 million reals, and it is determined that adjudication of the case using a panel of judges is appropriate, taking into consideration the number of parties and any other relevant circumstances. B. Cases in which it is established by law that the case should be heard and adjudicated by a panel of judges. 3. A panel described in paragraph 2 shall consist of 3 judges, one of which shall be the presiding judge. 4. Where a panel of judges conducts the trial and decision pursuant to the provisions of subparagraph A of paragraph 2, the panel shall issue a ruling as such. Article 24. Deliberations of panel. 1. The deliberations of a panel in a case shall not be open to the public. 2. The deliberations shall be commenced and controlled by the presiding judge. 3. Each judge shall express her opinions during the deliberations. 4. The progress of the deliberations, as well as the opinions of the judges and the size of the majority, shall be maintained in strict secrecy. Article 25. Decision by panel. 1. A case shall be decided in accordance with the opinions of the majority of the judges comprising the panel. 2. Each judge comprising the panel shall be given an equal vote. Section 3. Distribution of cases and exclusion and challenge of judges, etc. Article 26. Distribution of cases. 1. The distribution of cases within a court, and the order of appointment of substitute judges where there is a problem in using a particular judge, in a case, shall be determined in advance for each year by the president of that court. 2. Cases shall be distributed automatically to each judge pursuant to paragraph 1. 3. the distribution of cases within a court and the order of appointment of substitute judges where there is a problem in using a particular judge, as described in paragraph 1, shall not be changed during the year except where one judge is deemed to have an excessive workload, or where a judge retires or is transferred, or where there is a continuing problem in using a particular judge due to the long-term absence of the judge or other reasons. Changes made for these reasons shall be decided on by the President of that court. Article 27. Exclusion of a judge. 1. A judge shall be excluded from performing her duties in any of the following situations: b. Where the judge is a relative by blood of a party within the sixth degree of relationship, or is or was a relative by affinity within the third degree of relationship; c. Where the judge is the guardian of a party; d. Where litigation is or was pending between the judge and a party; e. Where the judge has become a witness or an expert witness in the case; f. Where the judge is or was the attorney or assistant for a party in the case; or g. Where the judge has participated in arbitration in the case, has participated in a prior decision in the case regarding which an appeal was filed or in a decision of an inferior court, or has offered legal advice in the case. 2. Where any of the reasons for exclusion described in paragraph 1 exist, the court shall render a decision to exclude the judge upon motion or on its own authority. Article 28. Challenge of a judge. 1. Any party may challenge a judge where circumstances exist with respect to the judge that would hinder the impartiality of the judge's adjudication. 2. A party who has made oral argument or has made a statement during the preparatory procedure for oral argument before a judge may not challenge that judge. However, this shall not apply where the existence of the ground for challenge was unknown to the party, or where the ground for challenge arose after the making of the argument or statement. Article 29. Recusal. A judge may recuse herself from a case with the permission of the director of the court to which the judge belongs where the provisions of paragraph 1 of Article 27, exclusion of a judge, or paragraph 1 of Article 28, challenge of a judge, apply. Article 30. Ruling on exclusion or challenge. 1. The exclusion or challenge of a judge shall be determined through a ruling rendered by a panel of judges of the court to which the judge belongs. 2. A judge may not participate in a decision regarding her own exclusion or regarding a challenge submitted against her. However, the judge may offer an opinion with respect to the motion for exclusion or challenge. 3. A motion for exclusion or challenge shall be made in writing and by establishing to a preliminary showing the existence of the grounds therefor. 4. Where a motion for exclusion or challenge is filed, the proceedings in the case shall be halted until the ruling on the motion becomes final and binding. However, this shall not apply to the preservation of evidence or other urgently needed actions. 5. An appeal may not be filed against a ruling ordering exclusion or granting a challenge. 6. A tromtoa appeal may be filed against a ruling denying exclusion or challenge. Article 31. Mutatis mutandis application to court clerk. The provisions of this section shall apply mutatis mutandis to court clerks. In such cases, the ruling on a motion for exclusion or challenge shall be rendered by the court to which the court clerk belongs.